General Counsel of the CAR, California Association of Realtors, and Gov has been with CAR since 1985 and managed CAR member legal services program in Los Angeles. Gov advised realtors through the hotline on all aspects of real estate law, and he trained and supervises other hotline attorneys. Gov received his bachelor's degree in history from the Princeton University and his Juris Doctorate from the University of Pennsylvania. He has written for California Real Estate magazine, co-authored CAR continuing education courses, and is a master instructor for the education division of CAR with certification from the Department of DRE. So Gov is so important for our industry, and he's so invaluable to us. He always teaches us. Of course, he always updates the purchase agreement. Now, please help me to give a very, very warm welcome to our special guest, our good friend, Mr. Gov Hutchinson. Gov, please.
All right. Hi, everybody. I missed the donuts that I get when I see you in person. So hopefully we'll get the donuts again one day. But today we just have to talk on Zoom. As always, I want to give you an update of the legal stuff you need to know. Okay, are you ready? And if you have questions when I'm talking, you can just put them into the chat and I can answer them as I go. I probably have time at the end also if you have questions. But let me just start with, some of you might have heard that yesterday, the California Department of Public Health came out with a new ruling saying that you can do open houses. But guess what? Before you get excited, local rules still take precedence. Los Angeles County still prohibits open houses. So just because the state of California allows you to do open houses, right now in LA County, you still can't, because the local rule takes precedence when it's stricter than the state rule. So hopefully the LA County rule is going to get changed very quickly. If any of you have listings somewhere outside of LA County, the new rule is that you treat open houses like any other so-called gatherings, meaning it depends on what tier you're in: purple, red, orange, yellow. For example, if you're in, I think LA is yellow tier now, you could have an open house with like 50 people, although people still have to wear masks. And if you're not related to the person you're with, you have to stand 6 feet apart. And that would limit the number of people. If it's a small house, obviously you can't fit 50 people in there at the same time. If people have to stand 6 feet apart, if they're not related. But as I said, LA County, it doesn't matter yet, because LA County specifically still prohibits gather more than 2 people and 1 agent at a time in a property. So unfortunately, you can't get too excited yet in LA County. Hopefully this is going to change very soon, but we'll keep you posted. Okay, LA County and some other counties have their own specific rules that are stricter than the state rule. Okay, as for the other COVID rules, hopefully they're going to be changed soon also. For example, you know, right now you're supposed to clean the property after every showing. I think that's going to change soon. Things like that. Hasn't changed yet. And if that changes, that would be LA County also, because LA County doesn't have any specific stricter rule than that. And there's also, what about these PED forms that are so annoying that you have to use every single time you show a property, that might go away too. And if that goes away, that would go away LA County also. So this all might happen. I know it's very complicated, but in the next few days, I'm looking for there are probably going to be some changes on the cleaning rules. And there might be some changes on using the PED form. You're not going to have to use it every deal. You might not have to use it at all. But today, as of today, that hasn't changed. So stay patient for a few more days. As of today, every time you visit a property, you're still supposed to submit a PED form, and you're still supposed to, open the doors and clean the doorknobs and the countertops and the light switches and leave the lights on, open a window. All the stuff you've been doing the last year hasn't changed. The only thing that's changed today so far is open houses. And unfortunately, it doesn't affect you in LA County yet. So if you guys listening to me in LA County, as of today, nothing has changed since yesterday. But stay tuned, okay? Things are happening fast now. And that change to the open house rule from the Department of Public Health was they said that's just the first step. More is coming. But right now, forget I said anything, actually, because you guys listening to me in LA County, not a single thing has changed for you regarding COVID as of today. Okay? Stay tuned. Change is happening. The whole state's going to open up June 15th, supposedly. And I think all this stuff's going to happen. But today is what, May 13th. But I think we're going to have real estate changes before then anyway. Just stay tuned. I just want to mention that because I know a lot of you might have heard about the open house thing, but it doesn't affect LA County yet. Okay. All right. So that's the first thing I wanted to cover. COVID hasn't changed. COVID is going to change soon. All right. Now let me talk about things that have actually changed. Let me talk about actual new laws and new forms that you want to know about. Okay. All right. I would say there are 3 big things and a bunch of little things. Okay. So I'll start with the 3 big things that every realtor needs to know. The biggest one is, and I apologize, this is also a little complicated, but anyway, the biggest one is there is a new disclosure law in California now when you're selling houses. We have not had a new disclosure law for about 15 years. For the last 15 years, if somebody asked me, okay, Gov, I'm listing a house, what are the disclosures I have to do? And I always said, think of it as NHD plus 4. Number 1, do an NHD report. And then there's 4 other things you pretty much always have to think about. Number 1, the transfer disclosure statement. Number 2, the seller property questionnaire. Number 3, the federal lead paint form if it's a pre-78 house. And number 4, the disclosure booklets. Remember, there are 4 of them. So NHD plus 4. Well, you know what? Now it's NHD plus 5. Because every time you take a listing right now, you have to figure out if the property you have listed is in a very high or high fire zone. If it is, then you have a new disclosure requirement. And the new disclosure requirement, to make it complicated, there's 2 parts to it. There's one called fire hardening and one called defensible space. The fire hardening part has taken effect right now. It's the law right now. The defensible space part only applies on July 1st. But it applies to all escrows that close after July 1st. So you might open an escrow today, and if you don't think it's going to close to after July 1st, then you got to take care of the defensible space part also. All right. So let me tell you exactly what that means. Okay. If you're, what is a fire zone? Do you know every one of us in this room, the Zoom room today, all of us that live in a house, there's 4 possibilities. You're not in a fire zone, you're in a moderate fire zone, you're in a high fire zone, or you're in a very high fire zone. This new disclosure law only applies if you're in the last 2. If your property is not in a fire zone, you don't worry about it. If you're in a moderate zone, you don't worry about it. If you're in a high or very high and you're selling, there's a new disclosure, which means every time you take a listing, you got to figure out what type of zone are you in. And this is why you have NHD companies. There's several of them today. They will tell you, they will help you determine if the property you have listed is in a high or a very high. The NHD report itself has 2 fire zones. One says very high, one says wildland fire area, state responsibility area. If neither box is checked on the NHD, you're not in a fire zone. If the very high box is checked, obviously you're in a very high zone, you got to do the form. If the very high box is not checked, but the other box is checked, the wildland fire area, that means you're in a moderate or a high. Well, Gov, how do I know which one I'm in? That's you talk to your NHD rep. They will help you. They will tell you if you're in a moderate or a high. I know some brokers who their philosophy is, if I'm in any kind of fire zone, I'm going to provide this form. And that's fine. But if you only want to provide the form when it's actually required, then it's not required in a moderate. It is required in a high fire zone. But if you want to give it to moderate, that's fine too. So let's say you figure out your listing, it's in a high or a very high. Well, there's this form called the Home Fire Hardening Form. And on this form, if you've ever looked at it, the seller is saying to the buyer, hey buyer, I'm selling you a house in a fire zone. You might want to make some improvements to your house to make it more fire safe. And the seller has to answer 6 questions on the form. They got to tell the buyer if they have a wood roof, if they have single pane windows, if they have landscaping within 5 feet of the house. They got to disclose it, right? They got to tell the buyer. They don't have to fix it. Buyer says, oh, I don't like the wood roof. You need to put on a new roof. And the seller can say, somebody's barking. I think, Olivia, you need to mute yourself. Everybody needs to mute yourself except me. There we go. Okay. So, in other words, the seller doesn't have to fix their house at all. They just have to tell the buyer, hey, buyer, this house is in a fire zone, and I still have a wood roof, or I still have single pane windows. By the way, if the house is built after 2010, it was built under the new fire building code, if it was built in a high or very high zone, so you don't have to do this form in a house that's built after 2010. So as of today, May 13th, you only have to do the form if you're in a very high or high fire zone and the property is built before 2010. And that's the fire hardening part. But now to complicate your life, effective for escrows that close after July 1st, you also have to disclose defensible space. What is defensible space? Defensible space is, you have to, if you're in a high or very high fire zone, you have to have 100 feet buffer zone around the house. And that means in that 100 feet, you can't, your grass can't be so high. It's got to be a certain level. If you have trees, the trees have to be a certain distance apart. Things can't be too near the house. So anyway, that only applies if you're in a very high or high. So the new law says, starting on escrows that close after July 1st, the seller here's what has to happen. Either the seller has to provide certification that the property is in compliance with defensible space, or the buyer has to agree that they will obtain certification within 1 year after close. Let me put it this way. I'm in Culver City, urban environment. I don't have to worry about this. A lot of you are in urban environment, you don't have to worry about this. But let's say you're in a high or very high zone. Your property right now is supposed to have 100 feet of defensible space. That's already the law. The only thing that's changing is now you have to provide documentation that you're in compliance. Well, where do I get this documentation? CAL FIRE. CAL FIRE is aware of this law, and they told us they're hiring a bunch of new inspectors to be able to come out and give this certification that you're in compliance. Okay. And you can always call your local fire company also. So here's the deal. When you figure out you're in a fire zone, you think about it right now, or it's already May 13th. If I open escrow today, I might not close till after July 1st. So I better comply with the defensible space part as well as the home hardening part. Unfortunately, the updated version of the home fire hardening form that talks about defensible space isn't out yet. It'll probably be out next week. So if you have a listing right now that you don't think is going to close before July 1st, wait till next week. We're going to send an email to every realtor in California telling you, yep, the new fire hardening and defensible space advisory form is available. And then you're going to get that form. Remember, if you're not in a very high or higher zone, you don't care. You don't worry about it. But if you're in a high or very high fire zone, you're going to get this new form. It's called the Fire Hardening and Defensible Space Advisory. The initials are FHDS. And you're going to fill it out and give it to the buyer. As I said, the top part on the fire hardening, the seller just answers 6 questions. The bottom part on defensible space. Now listen to this. There's going to be 4 choices. Choice number 1. If the seller who's selling their house in this high or very high fire zone has already received certification from CAL FIRE that you're in compliance, you're just going to give that certification to the buyer. I suspect there aren't many sellers who are going to have that already. So you know what I think is normally going to happen? You're going to check the box on the form that says buyer is taking responsibility within 1 year after close to obtain the certification. I think 95% of your deals, even if it's in a high or very high zone, the seller has not obtained certification from CAL FIRE that you're in compliance. So the law says if the seller hasn't obtained the certification, the buyer is required within 1 year after close to get certified that their property is in compliance with defensible space. This is the law. It's not our choice. So the seller is going to be providing this form to the buyer, and the seller is going to be checking the box saying, since I haven't obtained the certification, buyer, you have a year to do it. And I guess you could negotiate that, but no seller is going to negotiate, say, I'm not going to do it. Seller, it's your responsibility. You have to do it. So buyer is going to say, what do I do? And you're going to say, well, within the next year after close, call up your local fire company or call up CAL FIRE and tell them to come out to the house and make sure you're in compliance with defensible space. Then they're going to say, what do I have to do to be in compliance? And right on this form, it refers the buyer to the code section. It's right on the form, Public Resources 4291, which will tell the buyer what they have to do as far as cutting the grass and cutting the trees. And we're going to have a Q&A that's going to come out next week. As soon as the form comes out, we're going to have a Q&A, and they're both going to be released at the same time. So you can give your clients the Q&A and the form right at the same time, and everybody will understand what to do. Now, I said there's other possibilities. So 99% of the time, it's either going to be the seller has obtained the certification. That's going to be unusual. And most of the time, the buyer is going to agree to do it. But there are a couple of places, and I haven't checked to see if LA is one of them. But there's a couple of places in California, I don't think LA County is one of them, where there's a local law that says in our local county where we are, the seller must get certified before close of escrow. So how do I know where I'm selling the house if I'm in one of those areas where the seller has to get certification by close of escrow? Well, on this Q&A we give you, it's going to tell you how to figure that out. Bottom line, I'm pretty sure LA County doesn't have any local specific law that requires certification at close of escrow. But some places in California, that's going to happen. And in those areas, it's not going to be the buyer agreeing to do it in a year. It's going to be the seller must provide it by close of escrow. I think that's going to be unusual. Okay. And there's actually a fourth possibility. Some places require the seller to provide the certification like within a week after acceptance, not before close of escrow. But it's unusual where you're going to be in these places with these local ordinances. I'm not sure, I haven't checked, but I don't think LA County has a local one. So you just got to do with the state one. Okay. Ling asked a very good question. What if the buyer doesn't get the certification after a year? First question is CAL FIRE going to be knocking on doors and keeping track of this and say, oh, it's been a year since you bought this house, you're not in compliance, we're going to fine you? We have no idea how that's going to work. I don't know if they're going to be checking up on people or not. And we don't know what the penalty is going to be either. But anytime there is a law, and anytime it says you're supposed to do something and you don't do what you're supposed to do, there's always a possibility you're going to have some penalty. And I don't know how aggressive CAL FIRE is going to be. Maybe they're going to keep a record of these things. Maybe they're going to write you a letter after a year to say, hey, we haven't got your certification. I don't know what's going to happen. Nobody knows. I'm just telling you what the law is. Okay. Let me get some questions because you've asked some question here. Caesar, you're right. The more laws, the more lawless people. Good comment there. Sean, if you have a wooden roof, does the seller have to indicate that on the TDS or SBQ? No, you don't. You only have to disclose that on this form, which is only required if the house you're selling is in a high or very high zone. If you have a wood roof, but you're in a moderate zone or you're not in a zone at all, you don't have to disclose you have a wood roof. Okay. By the way, a lot of you are probably urban areas. You may not ever deal with this stuff. I don't know. By the way, let me get some other questions. I said, Joyce, good question. If there's no agent involved, the seller is still required to do all these disclosures. Okay. Karen, when are we going to stop using the PED form? Stay tuned. Not yet, but stay tuned. Kinney, San Diego is not like LA, so now you can do open houses in San Diego County and Orange County. It's just LA County where you can't do it. Okay. If you're not in LA County, you just look at what tier you're in. Yellow tier, you can have 50 people. Orange tier, I think you can have 25 people. Red tier, you can only have 10 people. Purple tier, you can't do open houses yet, but I don't think anyone in California is still in a purple tier. Everyone is in. So if you're in Orange County or San Diego County or Ventura County or Riverside County, figure out what tier you're in. That'll tell you how many people you can allow in your open house. If you're in LA County, you cannot do it yet. Okay. As for rent increases are just like they always were. You can increase someone's rent unless you're in rent control. By the way, I should say that in California right now, there's a statewide 10% limit on increasing rent because we're still in a state of emergency. That's going to end soon. Other than that, if you're in city of LA, of course, you're limited by city of LA rent control. But if you're in San Gabriel Valley, like you are, you're limited only by California rent control. And California rent control says single family house, you can increase as much as you want. Duplex, increase as much as you want. Single family home, newer building, increase it as much as you want, subject to that 10% cap I said. If you have a building older than 15 years in San Gabriel Valley, you're limited by California rent control, which is, Patsy, as you said, it's 5% plus CPI. I don't think it's 3.6, Patsy. I think it's less than that, but I'd have to check for you. It's different county by county. So very complicated when you have to increase rent. No matter what, not more than 10%. If you're in older building, 5% plus inflation. If you're in city of LA or city of Santa Monica or city of West Hollywood, they have local rent control laws. You have to comply with that. Okay. All right. So I think we're done with the, Judy, I have no idea how much the certification they're going to charge you. No idea. Insurance will probably require it anyway. You're right. Vincenzo, heard anything about landlord must report rent paid to reporting agency? Not exactly sure what you're getting at there. Maybe send me an email. I'm going to give everyone my email address just in case you have questions that I don't get to today. All right. So hopefully we sort of understand this new complicated, if you're in a high or very high fire zone, there's a new form. It deals with home hardening and it deals with defensible space. The new version won't be out until next week. If you think your escrow is not going to close till after July 1st, get the new version. If you're already in escrow and you're going to close in a couple of weeks, you don't have to get the new version. You can use the existing version, the HHDA, which doesn't talk about defensible space because you're not required to deal with defensible space until you're in an escrow that's going to close after July 1st. All right, that's a mouthful. That's the most important. Next important law to talk about, Prop 19. It's the law right now. Good news. If you're over 55, disabled, or a victim of a wildfire, you got your house, you can take your property tax you're paying on your current house and move anywhere in California and take your low property tax with you, even though you buy a house that's more expensive. Okay, so what this means is, let's say I bought my house a long time ago for $200,000 and I'm paying property tax based on $200,000, but it's now worth $1 million and I want to move. I want to sell my $1 million house and buy another one. If the new one I buy is less than $1 million and I'm over 55 or disabled, I can move anywhere in California, sell my existing house for $1 million, buy my other one for less than $1 million, and take my low property tax I'm paying on based on $200,000, and that's the property tax basis on my new house. And I can do this 3 times. The old law says you can only do it once and you had to stay in Southern California. Now I can move anywhere I want and I can do it 3 times. But not only that, under the old law, the new house had to be cheaper than the old house. Now, under Prop 19, I can sell my $1 million house and buy a house for 1.1 million. And what's my property tax basis going to be on this new $1.1 million house? Remember, my current house is only 200,000. So if I sell it for $1 million and buy a 1.1, what's the difference between 1.1 million and 1 million? It's 100,000. I'm going to add that 100,000 to my property tax basis of 200,000. So when I sell my existing one for buy one for 1.1, my property tax basis on the new one is going to be 300,000, which is a lot better than 1.1 million, right? So there's a good, in other words, the idea of this is some senior people, or not senior people, you're over 55, you're not senior, you're just over 55. I'm over 55. I don't think of myself as senior, just kidding. Anyway, the point is, some people over 55 like me. I bought my Culver City house a long time ago. And before this law, if I wanted to sell it and buy a new house that was more expensive than that, I would get killed with property tax. Now I can sell my Culver City house and buy a more expensive house and not get killed with property tax. Maybe I should move to the San Gabriel Valley. Does anybody know a realtor out there? I'm just kidding. Okay. Anyway, so Prop 19 benefits me, and it may benefit some of your clients. So that's a good thing. And I got even better news for you. It took effect April 1st, but if they already sold their original house, in March or January or last August, if they haven't bought the new house yet, they can still take advantage of Prop 19, even though they sold the first part prior to April 1st. Remember, if you're staying in Southern California and you're buying a less expensive house, you're already good. You don't need Prop 19 unless you've already done it once. Under the old law, you can only do it once. Now, even if you already did it once, you can do it 3 more times. Okay. Before I go any further, yes, a couple of people asked about rent control. Dora, is there a list of citywide rent increase limit? If you're asking me about the city of LA or city of some cities have their own local rent control. You have to check with that city to see how much you can increase the rent. If you're not in a city with rent control, and I don't know where you guys are in West San Gabriel Valley, if there are any cities there of rent control. If you're not in a city, then you have county rent control sometimes. And I don't keep up on all the details. But if your city or county doesn't have a restriction, remember, if your building is older than 15 years, you can only increase 5% plus inflation. If your building is newer than 15, or it's a single family or a duplex, normally you can increase it as much as you want. But right now in California, there's a statewide COVID state of emergency, which limits you to 10% increase. If you want to increase someone's rent, call the hotline to figure out how much you can do it, right? It's complicated. All right. So you got Prop 19, right? Next thing, let's talk about third law everyone needs to know about is eviction moratorium and rent assistance. This is another complicated thing because you guys are in LA County. The question is 2 things. Number 1, can I evict people now? And number 2, if the tenant owes me money, can I get some government money to compensate me for the back rent my tenant owes me? So first, let's answer the first question. Can I evict a tenant right now? Well, if you weren't in LA County, I'd say you could evict them. The only reason you can't evict them is if they're not paying rent because of COVID. In other words, if they're doing anything else wrong, you can evict them. Or if you want to sell the house and you have a buyer, you can evict them. That's true in Orange County. That's true in San Diego County. That's true in Ventura County. That's not true in LA County. In LA County, until at least July 1st, a month and a half from now, the only way you can evict a tenant is if they're not paying rent and it has nothing to do with COVID. Then you can evict them. If they're creating a nuisance, you can evict them. If they're engaging in criminal activity, you can evict them. If they're damaging the property, you can evict them. Let's say they're not letting me show the property. In LA County, that's not grounds for eviction. They don't have to let you show it. Let's say they got subtenants they shouldn't have. Right now in LA County, not grounds for eviction. Let's say they have pets they shouldn't have. Right now in LA County, not grounds for eviction. Let's say I have a buyer who wants to buy the house that they're living in. Can't evict them yet in LA County. Hopefully that will all change July 1st. Hopefully on July 1st, the state eviction moratorium is going to go away. The federal eviction moratorium is going to go away. The LA County eviction moratorium is going to go away. You know what I think? It's not going to go away July 1st. I think it's going to be extended for at least 3 more months. I'm just guessing. It hasn't been extended yet. I think actually San Diego might have extended it, but anyway. And I don't, in my mind, I can't keep track of each county and each city. If you have a specific question, call the hotline. But I'm just giving you the big picture. The big picture is right now in LA County, just because you're selling the house, you can't evict. Orange County, you could. San Diego, Ventura, Riverside, you can. But this might change July 1st. So, okay, so that's point number 1, your limitation on eviction. But here's the good news. There is money now available for you as a landlord to get paid for the money the tenant owes me. Let's say I have a tenant and they haven't been paying me rent for 6 months because of COVID, or they haven't been paying for a year because of COVID. In other words, they sign the form that says they swear to God the reason they're not paying me is because of COVID. Under penalty of perjury, they sign the form and says, I have a COVID issue, that's why I'm not paying you rent. By the way, they still have to pay 25%. What if they're not even paying the 25%? You can evict them on July 1st, unless this gets extended. What if they are paying the 25%? What about the 75% they haven't been paying me? They owe me $20,000 of back rent. Well, on July 1st, you can sue them for the back rent. Well, I don't want to sue them, or I want to sue them, but they might not have the money. I want government assistance to pay me. Well, guess what? There's government assistance available. You go to this website called housingiskey.com. I'll put it in the website. I'll put it in the chat. housingiskey.com. When you go there, you look up the county or city where you're at. And it will tell you how to apply for rental assistance. It's different by county. It's even different by city sometimes. So you apply for the money. It's going to ask you to give the email address of your tenant, because the city or county is now going to send an email to your tenant, because they have to also apply for the money. It's a joint application. Of course, there's a catch involved. You're only eligible for the money if the income of the tenant household is less than 80% of the area median income. That means the LA County median income. We have a Q&A on our website called Eviction Moratorium and Rental Assistance. And this will tell you how to there's a link where you can figure out what is the median income in LA County for a tenant household of 4 people, and what's 80% of that? So let's say you got a tenant household, there are 4 people in there, they owe you this back rent. They're going to have, the tenant's going to put on their application what their income is. If that income is less than 80% of the LA County median for that type of property, and a lot of tenants who aren't paying rent, it's because they've lost income, right? So a lot of tenants, let's say they're eligible because they're making 80%, their income is less than 80% of the area median income. Now you have an eligible tenant, which means you're eligible to get the money. So the city or county is going to say, okay, how much does a tenant owe you? $20,000. All right, we're going to give you $16,000. And you say, thank you very much, but I'd like 20,000 because they owe me 20. They don't owe me 16, they owe me 20. And they're going to say, if you want this money, you have to forgive 20% of what is owed you. If you want, the landlord says, I don't want to forgive anything. I want every cent that they owe me. Well, you're not going to get the government assistance. You can now, in that case, they're only going to give you 25% to cover the tenant's minimum. And then you can sue the tenant for the other 75%. But you're not going to get any rental assistance. Now that's the current law. There was $2.5 billion sent to California for this. But I got sort of good news for landlords. Under the new stimulus bill that the president signed, there's another $2.5 billion coming to California to compensate landlords. So if they tell you that they're out of money, that's not going to be for long because there's more money. I don't think they're out of money yet, but there's more money coming. I don't think any landlords, I think the money's not going to run out. The question is, on this second fund of money, we're trying to lobby so that it doesn't have this requirement that you have to forgive 20%. It might be that you'll be able to apply for 100% of the back rent. We don't know yet. That hasn't happened yet. Okay, but that's the case right now. So please, if you're a landlord or a property manager, you can apply. Go to that website. You can apply for the rental assistance. Lorraine, it's only residential right now. Yes, only residential. Yes, Jenner, if you have a tenant not paying rent right now, but it's not COVID related, you can evict them right now. Well, how do I know the reason they're not paying? You have to send them the COVID eviction notice, not the normal 3-day pay rent or quit. You got to send them the COVID 15-day pay rent or quit. It's on zip form, PRQ, pay rent or quit. I think it's called the PRQC TP for transition period. If you try to use the 3-day notice, it'll say right on there you shouldn't be using this form. Anyway, you send them the 15-day notice. If they don't respond in 15 days with a declaration that they have a COVID reason, that means they don't have a COVID reason, means you can evict them right now. Okay? All right. Rita, if the current property owner wants to move into the rental property, can they evict the tenants? Not in LA County. Everywhere else, yes. Not in LA County till at least July 1st. It's really tough being a landlord in LA County right now. Okay. All right. So that's the latest on the eviction, the rental assistance. Let me talk about some other stuff. Those are the big 3 things, but there's a bunch of other things you need to know. Let's talk about, first of all, form changes. I told you the fire hardening and defensible space form is going to come out early next week. There's one more new form coming out end of June called transfer of listing, TOL. Have you ever had a situation where the agent right in the middle of escrow, they have a listing and they want to change offices? Well, that listing belongs to the broker. The broker can say, you're going to leave. You can't take your listing with you. It's my listing. But let's say the broker says, you want to leave, fine, you can take your listing. But I want you to compensate me for this listing. You have to at least give me something for allowing me to take this listing. Either a percentage if it sells or just a flat fee or whatever. The point is, starting end of June, we're going to have a form for this, where one broker can transfer the listing to the new broker. You can have compensation or not. There's a release of liability from the old, the new broker indemnifies the old broker, releases liability. The old broker assigns the listing to the new broker. There's the new broker has to give a new agency form to the client. I mean, you can do all this today. You can transfer a listing today, but we never had a nice form where you can easily, legally transfer the listing and take care of the liability issue and take care of the compensation issue and take care of everything all on one form. So you can do that. Juliana, yes, in FSBO transactions, all of these disclosures are required. That's how you convince a FSBO not to be a FSBO. You tell them, you better hire me because otherwise you got to figure all this stuff out for yourself. Anyway, all right. So that's new form. What about, are there any other forms that are going to change end of June? Just a couple changes. Your listing form that you all use, the RLA residential listing form, is going to have a couple changes. It's going to have a new paragraph on these buyer letters. You know how in the fair housing addendum that you all, it's attached to your listing and your purchase contract, there's a paragraph on there that says to the seller, you might want to think about, maybe you shouldn't accept these buyer letters because these buyer letters, these personal letters that the buyers submit with their offer, often reveals to the seller, you know, they write letters like, yeah, my husband and my 3 kids will love to live in this house. It's a beautiful house. My husband's a dentist. It's a perfect house for him to open his dental practice. We just moved here from Taiwan. It's a perfect place for us. What's wrong with that letter? What's wrong with that letter is now the seller knows whether these people are married, they know if they have kids, they know where they're from, they know what they do for a living. As a seller, it's better if you don't know all that stuff. Because if you know that stuff, you can be accused of bias. Let's say you don't sell to that person. They come back, oh, I guess you don't like people from Taiwan, that's why you didn't sell to me. Or I guess you don't like people with children, that's why you didn't sell to me. Or I guess you don't like dentists, that's why you didn't sell to me. As a seller, I don't want that letter because I don't want to know the personal details about the buyer, since if I don't know about them, I can't be accused of bias later. See what I'm saying? Remember, in California, you can't discriminate against anybody. You can't discriminate race, religion, color of skin, country of birth, age, gender, disability, source of income, gender identity, sexual orientation, medical condition, citizenship status, immigration status, language status. There's 22 categories, which is why we have that fair housing form that you should make sure your client signs so they understand that they can't discriminate against anybody, which means when they're choosing between 2 different buyers, they're not supposed to make their decision based on any of these characteristics of the buyer. You're supposed to base it on the numbers. How much are they offering? How long is escrow, contingencies, down payment, deposit, etc. By the way, there are some people you can discriminate against. You know who you can discriminate against, for example? Investors. You get 2 offers. One's from an investor, one's from someone who wants to live there. The seller has the right to say, I'm going to sell to someone who's going to live there. I'm going to discriminate against the investor. Investors aren't a protected class. Not everybody's a protected class, but a lot of people are. Okay? All right. So there's going to be a new paragraph on the listing form where the seller is going to have to make a decision. Number 1, do you want these letters or not? They could check the box, I don't want the letters. So the listing agent knows I'm not going to give you the letters. Or the seller is going to check the box, even though you told me it's not such a good thing, I still want the letters. And then it's going to say right on there, if you get these personal letters and you rely on that personal information, you are acting against the advice of your broker. But I mean, they can still choose. If they want the letters, they can get the letters. You've told them the risk. You've told them don't rely on personal information if that's what but if they still want the letter, they still have the letter. The listing form is also going to have a new paragraph on, I think we have a new paragraph on coming soon, because, well, that might happen. If there's a settlement, if the rules come out between now and July regarding what coming soon means, there's going to be a new paragraph. Right now, there's no official agreement on what coming soon means and what you can market. So right now, when people ask me coming soon questions, I say, talk to your own MLS. What about days on market? There's going to be a new paragraph that's clients have different ideas of what they think days on market means. So there's going to be a section of the listing form that says, seller, talk to your broker, so they will explain to you what days on market means in your MLS. Now, hopefully soon we're going to have a statewide rule that says this is what days on market means everywhere. And this is what coming soon means everywhere. But right now it's MLS by MLS. They do it differently. So we're going to have uniform rules, just it hasn't happened yet. Okay. Another thing on the listing form, it's going to have a checkbox where the seller can instruct. I think a lot of people now, you order your disclosures up front before you even get a sale, right? You get a listing and you start ordering NHD, order prelim, you order HOA docs. Well, now it's going to be right on the listing form where the seller can check the boxes saying, yes, I'm authorizing you to order this and this and this and this. Because I think that's becoming a lot more. It used to be wait till you opened escrow before you ordered that stuff. Now, a lot of people, it's probably a good idea to order it earlier, right? Anyway, so that's a change in the listing form. The statewide buyer and seller advisory is going to have a new paragraph on home hardening and defensible space. So that's good. It's also going to have, interesting, it's going to have a new paragraph on sea level rise. I don't know if any of you guys take listings on the coast, but there's going to be a new disclosure telling people, hey, you know, the sea level's rising because of global warming. If you buy a house on the coast, there's a possibility that the Coastal Commission is going to say, you can't improve this house. You can't make certain changes to the house because of anticipation of sea level rise. And you don't want the buyer coming back and saying, hey, you sold me this house on the coast. You didn't tell me that there was a possibility that they were going to restrict my ability to improve it. Yes, Jim, whether it's a hoax or not, the Coastal Commission is going to put restrictions on what you can do on your coastal property. So it's just a disclosure. Another thing, have you ever heard about someone who's all of a sudden a bear walks into the backyard of their house, or a coyote? You know what they do sometimes? They sue the realtor, says, you never told me bears could walk into the backyard of my house. So there's going to be a new thing on the SBSA that says, guess what? It's possible that wildlife is going to walk into your backyard. The realtor is telling you this is possible. Don't blame the realtor if it happens. Okay. So that's going to be a couple changes. We have a form called the Property Images Agreement. If you hire a photographer to take pictures of your listing, sometimes they use drones and sometimes they don't follow the drone rules. And sometimes the drones cause damage. So now there's going to be a clause on this form. This is the form the agent uses to hire the photographer. It's going to say on the form, the photographer takes all responsibility for complying with the drone rules, and they take all responsibility if the drones cause any damage or lead to lawsuits or anything like that. Okay. And then we have a form called the referral fee agreement. Let's say you give someone a referral and you sign this form and they agree that if the person you're referring me buys or sells anything in 12 months, I'll pay your referral fee. Well, now it's going to say something like they don't have to close in 12 months, but as long as they enter into contract in 12 months, or it could be longer than 12 months, whatever you want. So those are the changes to the forms you're going to see in June. 2 new forms. One's coming out next week, right? The fire hardening form is now going to be the fire hardening defensible space. And then the transfer of listing form is going to come out. Thanks, Jim, very much for your comment. By the way, you know what's going to happen in December, right? The forms change in June and December. I'll give you a heads up what's going to happen in December. There's going to be only one new form, but it's going to be a big one. The purchase contract, the RPA is changing. So please, I am going to start teaching classes in mid-August. I'm going to be teaching classes August, September, October, November, December on the new purchase contract. Not just me, other people are going to be teaching them too. You're probably going to want to sign up for a class. You don't have to, but it's going to be a lot of changes. It's probably worth taking a 4-hour class, okay? All right. Let me do a couple more questions. Dan, the tenant won't cooperate to show. They don't have to in LA County. What happens if they don't move out by the time of closing the deal? Well, remember LA County, you can't evict them yet. That may change in a very short time, hopefully by July 1st. But right now, if the tenant doesn't move out, and tenant doesn't have to move out. That's a big problem in LA County. Mindy, if the tenant's on a month-to-month, they've been there less than a year, tenant's son is destroying the property. Yes, you can give them a 3-day notice. That's grounds to evict if the tenant is damaging the property. 3-day notice to evict. Joanna, is there a form for eviction because the landlord wants to sell? Yeah, we got this form called the NTT CTRA, Notice to Terminate Tenancy under the Tenant Relief Act, but don't bother trying to use it in LA County, because in LA County, until at least July 1st, you cannot evict just because you're selling the house. If you were in Orange County or San Diego County, yes. If you have a buyer in contract to buy the house, you can evict the tenant. Yes, Caesar, tigers and bears and whatever, and snakes, Mindy, yes, all wildlife. The point is, Philip, this form takes care of you. I'm recommending that you give the buyer the statewide buyer and seller advisory. By giving them that form, you have disclosed that there's a possibility that wildlife will come onto their property, so they can't blame you. But remember, this change is only going to take effect end of June. If you don't want to wait till then you should put on your TDS. Bears sometimes come onto this property or something like that. Okay. Ling, yes, I guess I'm already teaching a class for you guys in November. You guys are lucky. I'm giving you guys a private class just for you. That's because you asked early, which is good. November 2nd, thank you. What about rentals? Cecilia, good question. You don't have to tell the tenants about the animals. You don't have to tell tenants anything. They're on their own. Just kidding. As you know, there's certain things you have to tell tenants. You got to give them the bed bug disclosure, and you got to give them the lead paint disclosure. But you don't have to give a TDS to the tenants. You don't have to give a seller property questionnaire. You don't have to disclose things like wildlife. Tenants don't get the same disclosures that buyers get. Okay. You told me 10:15, so I got 3 or 4 more minutes. I think you're trying to get rid of me here, telling me thank you all the time. But anyway, anything else you need to know? I would say there's a new law on HOAs. If any of you guys are like me, you live in an HOA, there's a new law that says HOAs have to allow at least 25% of the people who live there to rent out their property. It used to be an HOA could say you can't rent it out, or only 10% can rent it out. They have to allow at least 25% to rent it out. And also remember, let's say I have a house in an HOA and I've legally converted my garage to a rental, or I've legally converted my back bedroom to a rental, or I built a accessory dwelling unit in the backyard. You have the right to rent that out too. In fact, you have the right to rent that out even if more than 25% are already renting out the whole property. Everybody has the right to rent out their excess. HOAs cannot stop you for that. Okay. So that's a new law. To summarize everything, remember we're waiting, you're going to stay tuned and you're going to read your emails from CAR because things are changing. The rules on showings are probably going to, and the cleaning is probably going to change in the next few days. Hopefully the eviction moratorium is going to change on July 1st. So pay attention to your emails because we're in a time of transition. We're in a time of change. So things keep changing. Ling Chow, last question. What about door knocking? Today, still no. But that's another thing that might change soon. What about dropping off flyers without knocking on the door? You can do that now. Gov has just given you permission to do that. Earl, there's an agent that bought a home in Bradbury, had the bear come every day because they were feeding the bear. Probably not a good idea. Kevin, yes, in LA County until at least July 1st, landlord cannot evict the tenant just because you're selling. Now I'm done. I'll turn it back to Patsy or whoever.
Thank you.
Pauline,
Really,
Pauline, hi Pauline.
We don't want to let you go. We want you to stay more and another more 1 hour, okay? Like at St. Gabriel boards, okay. We really appreciate your valuable time. You're the most important person to Realtors, especially to West St. Gabriel Valley Realtors member. What a wonderful morning with you, Gov.
Thank you, and I love this association, one of my all-time favorites.
Yeah, we appreciate it. When you come, we are not give you donut, we give you a big meal. Okay.
Oh, really? I'm gonna
Promise.
that. Next
Promise,
time I
okay?
come, I get a big meal. Okay.
Okay. Yeah.
All right.
And we want to say very sincere thank you to you on behalf of West St. Gabriel Valley Realtors. We would like to thank Mr. Gov Hutchinson for your detailed legal updates, and following by looking forward to seeing you November 2nd at 9 a.m. a 4 hours special time with our member.
Yes.
We feel so privileged. We booked your time in an early stage. So we are proud of, we can have you for
have me personally,
4 hours,
yes.
okay? Not only 1 hour, thank you.
Okay.
And we're looking forward to that update after November 2nd update, and then following the next month is December, and that will be effective, the new RPA form. And folks, remember, register at wsgbr.com right now, and to get a special members benefit from our member, from our board, okay? So thank you again.
Everybody. Bye, everybody.
Thank you again. Thank you again. Now we move on to attendance drawing. Can we have the lucky draw wheel ready? Yes, Elaine. We will have 3 $10 Amazon e-gift card today. Winners, please type your DRE member name and email in the chat box. The first winner is Jason Wade. Jason
is here. Jason is here.
Congratulations.
Jason, can you type in your email address in the chat box, please? Jason?
I will say today's three lucky winner is pretty lucky because we have over 200 attendees today. Okay, second winner, well, it's going to Xin Li. Is Xin Li here?
Yes, Xin Li is here. Hello, Xin Li, are you there? Can you put down your email address? Jason hasn't put down email address yet. Hello.
Okay. Jason.
Did they just have us on a radio mode? Jason and Xin, nobody's replying us.
Jason, wait. Raise hand.
Okay, he raised his hand.
Jason Wei with Xiaobao, congratulations. Okay.
Put your email on the chat box, Jason, please.
Yes, congratulations. Let's draw the third winner.
Well, Xin, can you talk? Xin Li, hello?
Also reminder that they need to be WHGVR members.
Oh,
Okay.
Jane, Wayne?
No, Jane is not here.
Jane is not here. Okay, let's draw another one.
We're not getting emails. If we don't have your email, we cannot send you the gift card.
Jason Wei, Xin Li, please put your email into the chat box. And Mike Kalagi.
The person is here. It had to be a Western Gabriel member.
Philip Chang, not yet, okay? We hope to draw lucky draw to your name in next.
Mike is not replying.
Not, okay.
Hello, Mike. You could unmute yourself or type. Okay, all three of them are not typing their email address to us. So what do we do? They know how to type?
Well, Jason Wei, he did say he was here.
Right, do we have his email address?
Yes, we can get his email address, but Xin Li did not respond at all. So we should draw again for Xin Li and Mike Kalagi.
Okay, so we have another two lucky winner to draw.
I know the rest of you are all here. We know that, okay?
Yes,
Including myself.
including myself.
Okay, Mike, wait, hold on. Mike is here. Mike.
Oh, Mike is
oh,
here,
yeah.
congratulations.
Okay, so we have one drawing, only one.
MKALHI.
Okay, well, who is this? Affiliate.
Unita Wu.
She left already. Let's go.
Okay, one more. Lucky winners.
I'm here.
Me too.
You see, even though I typed in my email, then
They
still say, then say I didn't see my email. I don't know what's going on.
No.
It's a chat box, right?
Lena,
Yeah.
Lena
Oh,
too.
hold on.
Xin Li is here.
Oh,
Okay.
let me see.
Okay, that's it. So we have three, right?
So
Well,
we
have
Sending
three.
it to, send it to everyone.
Jason,
Yeah, no, it's because it's for the host. Right?
You type
It's
it
a host of
directly
Adam?
to
I don't know.
Belen.
Say something. She need.
Okay, so where it says Adam Long, click that name,
Oh,
and then who's the director? And then
I don't
click the
know.
director's name.
Sandra Lan.
Okay, no. Okay, hold on. We have somebody talking. Okay, listen. We're gonna mute you, and we have all three.
yes, Jason Wei, Xin Li, and Mike.
Yeah.
Congratulations for your three. Will get $10 Amazon e-card from Western Gabriel Valley Realtors. How wonderful morning with you. Please make sure to attend our education classes. A list of upcoming classes displayed on our screen. And I want to read this class date and time for you. So because some attendees is driving. The first class is Tuesday, next Tuesday, May 18 at 11 o'clock. And this is a Saver at Home and Learn. The class will conduct by Mark Wu regarding the condo insurance. CRMS virtual training will happen on next Wednesday, May 19 at 9 a.m. This will be very good classes. And At Home with Diversity, AHWD certification course. I want to mention this one, and encourage all of you to join this class because we only charge $19 for our member. Original price is $99. This is a full day class and get certified by NAR. With this certification, you can treat it as a credit to join, I believe, the CIPS or CRS credit unit. So I would like to invite all of you next Wednesday, join this class. It's a very good class, especially right now. We stay home office, and then we can learn a lot of different things for at home with diversity. And the Monday, May 24th at 9:30, if you need to have a zip form questions, we have a virtual zip form plus training. Mark down your calendar, May 25th, May 25th, we will have attorney Paul Chan come to talk about eviction in the pandemic world. Right now, I want to invite you join us to build your global knowledge and networking contact with the CIPS class, Certified International Property Specialist. This is a 5-day class, May 24 to 26, Monday to Wednesday. First 3 days will be in virtual, and second portion is June 28 to 29, Monday to Tuesday. This might be a live class at our board, so we will let you know if that can be live, if allowed it. Special price offered to our member, only $3.99. Non-member is also welcome. The best price is $4.99. We wish can see you all to think about learning global. And with a global knowledge, don't miss out another GBC Global Best Counsel present you this valuable section, May 26th, Wednesday at 10:30. CREA, Canadian Real Estate Association, will present you recent market portfolio for each area. Which area? WSGVR, we have our President-elect Brian Chang and our CEO, Albert Trang, will present California, the market portfolio. And we also have a guest from Ontario and Arizona. Why don't you just register right now and let's join together to learn more about global. When the day reopen back to normal, we'll be so strong with knowledge and networking world. Thank you so much. And thank you everyone to joining today's meeting. Please make sure join next week, May 20th, Thursday at 9 a.m. as WSGVR Foundation will present you and honors local students with scholarship. Please support our affiliates with your transaction. This meeting is now adjourned, and we see you next Thursday at 9 a.m.